I don't know. I am not supposed to tell you. Sir, please, I have already told you there is a judgment of the same kind.
In that judgment, it has been said that section 14 will not apply to guarantors.
Sir, please. Sir, please. आपने जजमेंट पढ़ा नहीं है और आप कहते हैं you are trying to distinguish it. How that is possible, यार? That means you must have read that judgment and now you are showing your ignorance. If you have not read, then you can't make any distinction. And if you have read and you are trying to make a distinction, that means you have suppressed that fact that there is a judgment contrary to the judgment which you are citing. And in the subsequent judgment, the judgment passed in the case of P. Mohan Raj was considered. Fine. It was not my duty to tell you, but I have told you. That is all. Don't take it otherwise. I have told you. Otherwise, I would have written it in the judgment and fine. Sure.
May I humbly submit, my lords?
Sir, please.
The issue is, my lords, that judgment which my lords are considering to be a judgment.
Sir, if you have not read that judgment, then please don't make a comment.
My lords, kindly.
Sir, please.
I'm submitting, my lords. Let me be given a chance, my lords.
Oh, sir, sorry. I'm not here to tell you.
Then my submissions may be considered at least, my lords. That
Consider.
this is a proceeding, that the order of P. Mohan Raj.
No, sir, मैं कर तो रहा हूँ ना.
If I may make a submission that I would be at my lord's hands to.
Sir, you have already heard that once the proceedings have been initiated under IPC Act, then this proceeding under Section 138 of Negotiable Instrument Act would also be covered in the word of proceeding. Therefore, in the light of P. Mohan Raj, even the judgment passed by the trial court was nullity or it was not maintainable, and therefore the imposition of condition while granting bail to you, that is also bad.
I would add, therefore, the only issue which has to be added is P. Mohan Raj has considered Section 14 of the IPC, wherein it has been against the company, and subsequently Section 96 is a condition which is not available in Section 14, and it includes the words proceeding. Section 14 doesn't include the words proceeding, my lords. It has been interpreted by the Honorable Supreme Court that it would be, but whereas Section 96 is very specific, wherein interim moratorium applies from the date of filing till the date of admission, and from the date of admission, a 101 final moratorium would apply. Therefore, in that case, in that context, my lords, I had referred to the Punjab Haryana High Court judgment, wherein specifically this distinction between P. Mohan Raj and
भैया वो दे दो यार 2023 वॉल्यूम 10 SCC मेरे को दे दीजिए MCRC 17792/2024. This application under Section 482 of CRPC has been filed, seeking the following relief. It is submitted by counsel for the applicant that by judgment dated 13/3/2024 passed by JMFC Burhanpur in SCNIA/723/2019, the appellant has been convicted under Section 138 of Negotiable Instruments Act and has been directed to undergo the jail sentence of 6 months with compensation amount of ₹68,69,457.24. Being aggrieved by the said judgment of conviction, the petitioner applicant to file an appeal along with an application under Section 389 of the CRPC. Police system. It is submitted by a counsel for the applicant that applicant was the guarantor of Mrs. Shri Geeta Textiles Private Limited, who has committed a default due to non-payment of borrowed debts. Accordingly, the borrower moved an application under Section 94 of Insolvency Resolution process of the Insolvency Bankruptcy Code 2016 before National Company Law Tribunal Indore Bench for initiating undergoing the insolvency resolution process. White company petition bracket में capital IB/74 bracket में MP 2022. And it is submitted that as per Section 96, interim moratorium starts from the date of filing personal insolvency with effect from 14/10/2022, and therefore